A court decision just came down that changes everything for concealed carry holders across 3 states. And if you blink, you're going to miss it because the mainstream media has decided this story isn't worth your time. The Fifth Circuit Court of Appeals struck down 8 separate concealed carry restrictions in a single ruling this past March, and the implications are massive. We're talking about rules that have been on the books for years, rules that determined whether you could get a permit and where you could carry, and what hoops you had to jump through just to exercise a constitutional right. All of that just got wiped out in one decision. If you carry concealed, if you've ever applied for a permit, or if you've ever been told no by a government official who couldn't give you a straight answer, this ruling is about you. And if you don't know what just happened, you could be following restrictions that no longer exist or missing opportunities to challenge denials that are now clearly unconstitutional. Let's get into what actually went down, why it matters, and what you need to do right now to make sure you're on the right side of the law. The case is United States versus Rahim, but what most people don't realize is that the headline decision isn't the only thing that came out of this case. There was a follow-up ruling in March from the Fifth Circuit that took a hard look at 8 specific restrictions that states had been using to control who gets a concealed carry permit and where they can carry. The court didn't just tweak these rules or narrow them slightly. They struck them down completely. This was a panel decision, meaning 3 judges heard the case and ruled decisively in favor of gun rights. The vote wasn't close. The reasoning was clear. And the legal world noticed immediately, even if the press didn't bother to tell you. Here's the thing that makes this ruling so powerful. It's built entirely on the framework the Supreme Court established in New York State Rifle and Pistol Association versus Bruin back in 2022. That case changed the rules for how courts are supposed to evaluate gun laws. Before Bruin, courts used something called interest balancing. Basically, they'd weigh the government's interest in public safety against your Second Amendment rights, and more often than not, the government won. But Bruin said that's not how constitutional rights work. You can't balance away a right just because the government thinks it's a good idea to restrict it. Instead, the government has to prove that any restriction on firearms is consistent with the nation's historical tradition of gun regulation. If there's no historical analog, if the founders didn't regulate something in a similar way, then the modern restriction is unconstitutional. That's a massive shift. It's like the referee changed the rules at halftime, and now every gun law in the country has to prove it belongs on the field. The Fifth Circuit took that standard seriously, and in this March ruling, they applied it to a whole list of concealed carry restrictions that have been around for decades. They looked at who gets to deny your permit, what reasons they can use, what training you have to complete, and where you're allowed to carry. And one by one, they found that most of it doesn't hold up under the historical tradition test. Let's walk through the 8 restrictions that got crushed and what each one means for you. First up, subjective denial standards. This is the rule that says a local sheriff or police chief can deny your concealed carry permit based on their personal judgment. Maybe they don't like your attitude. Maybe they think you don't need a gun. Maybe they just have a bad feeling about you. Under the old system, that was often enough to deny your application, and you had no real recourse. The Fifth Circuit said that's unconstitutional. If the government is going to stop you from exercising a constitutional right, they need a clear, objective, law-based reason. They can't just rely on gut feelings or personal opinions. This is huge because it takes the arbitrary power out of the hands of local officials and puts the burden back on the government to justify their actions. Imagine if a government official could deny your right to vote just because they personally didn't think you were responsible enough. That wouldn't fly, and the court made it clear that the same principle applies to your Second Amendment rights. You have the right first. The government can only take it away if they have a legitimate, specific, legally defensible reason. Second, the court struck down blanket bans on carrying in all government buildings. Now, this doesn't mean you can walk into a courtroom or a legislative chamber with a firearm tomorrow. The court recognized that certain places, like courtrooms and legislative sessions, are sensitive locations where heightened security makes sense. But what the court rejected was the idea that any building with a government employee inside automatically becomes a no-carry zone. That means your local DMV, the post office, the county clerk's office, these places can't be declared off limits just because they're government property. The government has to be specific. They have to show that the particular location has a historical tradition of being restricted, or that it's genuinely sensitive in a way that's consistent with how the founders understood these issues. If there's no historical basis for the restriction, it can't stand. And the court pointed out that in 1791, when the Second Amendment was ratified, there was no blanket ban on carrying firearms into government buildings. People brought guns everywhere, including to public meetings and government offices. So if the founders didn't see a problem with it, the modern government needs a really good reason to create one. Third on the list, mandatory live fire training requirements. Some states require you to take a class, pass a written test, and demonstrate shooting proficiency before they'll issue a concealed carry permit. On the surface, that sounds reasonable. Nobody wants untrained people carrying firearms in public, right? But the Fifth Circuit said there's no historical tradition of requiring people to prove their skill before they can exercise a constitutional right. Think about it this way. Imagine if the government said you had to pass a test on constitutional law before you could vote, or demonstrate your knowledge of theology before you could practice your religion. That would be absurd. The court said the Second Amendment works the same way. You have the right first. The government can't make you jump through hoops to access it. Now, let me be clear. This doesn't mean training is a bad idea. You absolutely should know how to use your firearm safely and effectively. But there's a difference between encouraging training and requiring it by law as a condition of exercising a right. The court said the latter is unconstitutional. If you want to get trained, great. If a private organization or an insurance company wants to require training, that's their business. But the government can't mandate it as a gatekeeper to your rights. Fourth, the court struck down prohibitions on carrying in places of worship. Some states had laws that said you couldn't bring a firearm into a church, synagogue, or mosque unless the religious leader gave you explicit permission. The Fifth Circuit said that restriction has no historical support. In fact, the opposite is true. Colonial Americans regularly brought firearms to church. Religious services were often community gatherings, and in many cases, they were the only time people assembled in one place. Churches were social hubs, not just houses of worship. And there's documented evidence that people carried firearms to these gatherings for personal protection, especially in rural areas. Banning guns in churches is a modern invention, and it doesn't pass the Bruin test. Now, this doesn't mean every church has to allow firearms. Private property owners, including churches, can set their own rules. If your pastor says no guns in the building, that's their right. But the government can't criminalize it across the board. That's the key distinction. The state restriction is gone, but private restrictions still apply. Fifth, bans on carrying in any place that serves alcohol. This one causes a lot of confusion, so let me break it down carefully. Some states had laws that said you couldn't carry a concealed firearm into any establishment that serves alcohol. That means if you walked into a restaurant that had a bar, even if you were just there for dinner and weren't drinking at all, you could be arrested for carrying. The Fifth Circuit said that's too broad. They pointed to historical evidence that taverns in the 1700s were common gathering places, and there's no record of blanket bans on carrying firearms in those establishments. The government can absolutely prohibit carrying while intoxicated. Every state has laws against that, and those laws are still in effect. But the government can't ban you from carrying just because you're near alcohol. So under this ruling, you can walk into a restaurant that has a bar, sit down, order food, and carry your firearm legally as long as you're sober. But the second you take a drink, the rules change. You need to know the difference because confusing these two things can get you in serious trouble. Sixth, residency requirements for concealed carry permits. Some states said you had to live in the state for a certain period of time, maybe 6 months or a year, before you could apply for a permit. The Fifth Circuit said that's unconstitutional. If you're a legal resident of a state, you have the same Second Amendment protections as someone who's been there for 20 years. You can't delay a constitutional right based on how long someone has been paying state taxes or how recently they moved. This is huge for people who move frequently, for military families, for anyone who splits time between states. Under the old rule, you could move to a new state and be unable to carry legally for months. Under this ruling, as soon as you establish residency, which usually just means getting a lease and a driver's license, you should be able to apply for your permit. If a state tries to make you wait, you now have a Fifth Circuit decision you can point to and say that requirement is unconstitutional. Seventh, restrictions on magazine capacity, specifically for concealed carriers. A few jurisdictions tried to impose limits on how many rounds you could carry in your firearm, even if the firearm itself was legal to own and the magazine was legal in other contexts. The court said you can't single out concealed carriers and treat them differently. If a magazine is legal, it's legal. If it's not, then it's not. But you can't say that someone with a concealed carry permit is only allowed to carry 10 rounds while everyone else can carry 15. The government can't create arbitrary distinctions like that. Magazine capacity limits are a separate legal issue, and courts are still fighting about them in other cases. But this ruling makes it clear that if a magazine is legal for one group of people, it has to be legal for everyone. You can't carve out concealed carriers and impose special restrictions on them just because they have a permit. Eighth, and finally, vague good moral character clauses. A lot of permit applications include a question asking whether you're of good moral character, but they don't define what that means. So you could get denied because you got into a bar fight 10 years ago, or because someone wrote a negative letter about you, or because the official reviewing your application just doesn't like the way you answered certain questions. The Fifth Circuit said that's way too subjective. If the government wants to deny your constitutional rights, they have to point to specific, objective, disqualifying conduct. That means things like felony convictions, domestic violence convictions, restraining orders, or other legal disqualifications that are clearly defined in the law. They can't just say you're not moral enough and leave it at that. This is critical because it removes the arbitrary gatekeeping power that local officials have had for years. Under this ruling, you have the right to know exactly why you were denied. And the reason has to be something specific and legally defensible, not just someone's opinion of your character. So those are the 8 restrictions that got struck down. Subjective denials, blanket government building bans, mandatory training requirements, church carry bans, broad alcohol proximity bans, residency requirements, magazine capacity limits for carriers, and vague moral character standards, all gone. Now let's talk about what this means in practice. If you live in the Fifth Circuit, which covers Texas, Louisiana, and Mississippi, these changes apply to you right now. This is the law of the land in your area. But even if you don't live in one of those states, this ruling is already spreading. Lawyers in other states are citing it in their briefs. Judges in other circuits are reading it and considering how it applies to their cases. This is the ripple effect of Bruin playing out in real time. Every gun law is under the microscope now, and courts are being forced to look at history instead of just deciding what sounds reasonable. So what happens next? 3 things. First, states are going to appeal. They're going to ask for en banc review, which means the full Fifth Circuit would rehear the case instead of just the 3-judge panel. That could take months. They might also try to rewrite their laws in ways they think will survive the historical test. But here's the reality. The Bruin standard is clear. If you can't point to a law from the founding era or the Reconstruction era that's similar to your modern restriction, you're probably going to lose. Second, expect a wave of new lawsuits. Gun rights organizations are watching this closely, and they're going to file challenges in other circuits using this decision as a blueprint. We're likely to see cases in the Ninth Circuit, the Second Circuit, and the Fourth Circuit, all testing the same kinds of restrictions. Some of those courts are more hostile to gun rights, so the outcomes might differ. But that's actually good for gun owners in the long run because when circuits disagree, the Supreme Court is more likely to step in and resolve the issue nationwide. Third, federal agencies like the ATF are going to have to adapt. They've been relying on some of these restrictions to do their job, and now those tools are gone. You might see new regulations or guidance memos trying to work around the ruling. You might see Congress try to pass new legislation. But any new law is going to face immediate legal challenges. And under the Bruin standard, most of them are going to struggle. Let's get practical with 3 real-world scenarios. Scenario 1. You live in Texas, and you applied for a concealed carry permit last year. The sheriff denied it, saying you didn't demonstrate a sufficient need. You appealed, but got nowhere. Under this new ruling, that denial is unconstitutional. You can refile your application or challenge the denial in court, and you've got a Fifth Circuit decision backing you up. That's a game changer. Before, you were out of options. Now you have a clear legal path forward. Scenario 2. You're a Louisiana resident who likes to carry when you go to church. Your state had a law saying you couldn't do that without written permission from your pastor. You never asked because it felt awkward. Now that law is likely unenforceable. You still need to check your church's policy because private property owners can set their own rules. But the state can't criminalize it anymore. That's the key difference. The government restriction is gone, but private restrictions still exist. Scenario 3. You're moving from Mississippi to Texas, and you want to get your concealed carry permit as soon as you arrive. Texas used to have a 6-month residency requirement. Under the old rule, you'd have to wait. Under this ruling, that requirement is unconstitutional. You should be able to apply as soon as you establish residency, which typically just means having a lease and a driver's license. If they try to deny you based on how long you've lived there, you can point to this case and fight it. But here's the critical warning. Just because a restriction was struck down doesn't mean every local agency knows about it yet. Some sheriffs and police departments are still operating under the old rules. If you get denied or arrested under one of these restrictions, you need to know your rights and be ready to fight. That means having a lawyer who understands Second Amendment law. It means documenting everything. And it means staying calm and not escalating the situation. The law is on your side now, but you still have to navigate the system carefully. Let's clear up some myths, because there's a lot of confusion out there. Myth number 1. This ruling means you can carry anywhere without a permit. Absolutely false. The ruling struck down certain restrictions on permits, but it didn't eliminate the permit requirement itself in states that have one. If your state requires a permit to carry concealed, you still need to get that permit. What changed is how much power the state has to deny it and what restrictions they can attach to it. You still have to follow the law, you still have to apply, you still have to meet the basic requirements. This ruling just makes those requirements fairer and more aligned with the Constitution. Myth number 2, you can carry while drinking now. Wrong. The ruling addressed bans on carrying in places that serve alcohol. It did not address laws against carrying while intoxicated. Every state still has laws saying you can't carry a firearm while under the influence, and those laws are still fully in effect. If you drink and carry, you're breaking the law, and this ruling doesn't protect you. The difference now is you can walk into a restaurant that has a bar and carry your firearm as long as you're sober. You can sit down, order food, and not worry about being arrested just because there's a liquor license on the wall. But the moment you take a drink, different rules apply. Know the distinction. Myth number 3. This only matters if you live in the Fifth Circuit. Not true. Court decisions in one circuit often influence others. Lawyers in California, New York, and Illinois are already citing this case in their legal filings. Judges in other circuits are reading it and thinking about how it applies to their own cases. And if this case gets appealed to the Supreme Court, it could become the law of the entire country. Even if you live outside the Fifth Circuit, this ruling is shaping the future of gun rights nationwide. Pay attention to it. Share it. Talk about it. The more people know, the harder it is for states to ignore it. Here's what most people are missing. This isn't just about concealed carry. It's about how courts evaluate all gun laws going forward. Waiting periods, feature bans, licensing schemes. Every single restriction now has to meet the Bruin standard. The government has to prove that the restriction is consistent with historical tradition. Not that it's a good idea, not that it makes people feel safer, but that it actually fits with what the founders understood the Second Amendment to mean. That's a high bar, and a lot of laws aren't going to clear it. We're watching a transformation happen in real time. For decades, courts gave the government the benefit of the doubt. If a gun law seemed reasonable, it usually survived legal challenges. But Bruin flipped that script. Now the government has to prove its case with historical evidence, and when they can't, the law falls. This Fifth Circuit decision is proof that the new standard has real teeth. It's not just talk, it's changing outcomes. And that should give you hope if you care about your rights. Let's bring this home. The Fifth Circuit struck down 8 concealed carry restrictions in March, and the impact is going to be felt for years. Subjective denials, blanket government building bans, mandatory training requirements, church carry bans, broad alcohol proximity bans, residency requirements, magazine limits for permit holders, vague moral character tests, all of them gone. That's a massive shift in how the law treats your Second Amendment rights. And it happened because judges finally took the Constitution seriously and demanded that the government justify its restrictions with history, not just good intentions. Here's what you need to remember. First, know your rights. If you live in Texas, Louisiana, or Mississippi, these changes apply to you right now. If you live somewhere else, they might apply soon, and you need to be ready. Second, don't assume local authorities know about this ruling. Some do, some don't. If you get pushback, be respectful but firm, and get legal help if you need it. Third, this is just the beginning. More cases are coming. More restrictions are going to be challenged. And the more we stay informed and engaged, the stronger our rights become. This matters for you and your family because the ability to defend yourself is fundamental. It's not a privilege the government grants. It's a right you already have. And every time a court strikes down an unconstitutional restriction, that right becomes a little more real and a little more protected. We're not there yet. There's still a long way to go. But rulings like this are proof that the fight is worth it and that progress is real. Stay informed, stay engaged, and stay armed and legal.